I'm Katrina Wyman, professor here at the law school. I actually am not an administrative law expert. I teach environmental law and I teach property law. And but I am interested, though, in administrative law, and I have learned a great deal about it in the context of teaching environmental law. So the organizers of this conference have titled our panel Creative Destruction. And I believe that our mandate is to discuss the import of the major Supreme Court decisions from the past few years, such as Loper-Bright, Corner Post, Jarkissi. Now, as most people in this room are likely aware, these three decisions alone, leaving aside other relevant decisions in the administrative law revolution of the past few years, these three decisions alone have purported to overturn a 40-year precedent governing judicial review of agency interpretations of their governing statutes, open the door to new challenges of longstanding regulations, limited the ability of agencies to enforce their governing laws through administrative proceedings. So to set the stage for our discussion on this panel of this creative destruction by the Supreme Court, I'd like to invite the panelists to talk about some of these major recent judicial decisions in administrative law, some of their recent writings on these developments, and what they think these developments portend for the next few years and challenges to some of the actions that we've seen in the past few weeks. So I'm just going to briefly introduce our panelists. Immediately to my left here is Lisa Bressman, Vice Dean, and David Daniels, Allen Distinguished Chair in Law at Vanderbilt Law School. Following along here on my left is Kristen Hickman, Associate Dean for Research and Intellectual Life, and the McKnight Presidential Professor in Law at the University of Minnesota Law School. Then we've got Anita Krishnakumar, Agnes Williams Sesquicentennial Professor of Legislation at Georgetown Law School, and Tom Merrill, Charles Evan Hughes Professor of Law at Columbia Law School. So I'd like to invite each of our panelists, starting with Lisa here. We'll just kind of run down the line, starting with Lisa to speak, give some opening remarks for up to 10 minutes. We've been allocated each by the organizers of the panel.
Can you hear me? Oh, you can. That's nice. Well, it's been an interesting semester to teach administrative law because I felt like I had to check the news before I walked into the classroom, which I did. I'm not going to talk about the most recent developments. Instead, what I'm going to talk to you about is statutory stare decisis, which is an issue that is a little bit to the side, I think, of the overruling of Chevron and Loper-Bright, but I expect that it will be front and center for lower courts, so I'd like to talk about that today. Before Loper-Bright came down, I wrote a short piece predicting that overruling Chevron would not change judicial review as much as we might expect. So courts would continue to review agency interpretations in basically the same way they had before, using their traditional tools of statutory interpretation to decide what statutes mean, and they would rely on agency interpretations the more technical or complex the issue under consideration was. The level or degree of deference might change, it might be different, but for the most part, it wouldn't matter all that much. Perhaps agencies would lose more often than they had before, but that might be because of textualism, which is not attributable to overruling Chevron. Early evidence suggests that maybe this is right, but regardless of whether it's right, it's not the whole picture after Loper-Bright, and that's what I want to talk about this morning. By the way, I forgot to open by thanking the NYU Law Review and the Institute for Policy Integrity. I'm very grateful to be here, so let me take myself down a little bit. Okay. The whole picture after Loper-Bright. So there's another issue. How courts treat all the precedent, the prior cases in which they affirmed an agency interpretation under Chevron Step 2. That is, the statute was ambiguous and the court deferred under Chevron deference to the agency's interpretation. Well, Loper-Bright had something to say about this. The court had something to say about this in Loper-Bright. Loper-Bright instructs reviewing courts to independently determine the best meaning for a statutory provision, even if the statute is ambiguous. And if revisiting statutory language in the future, the question is, are they hamstrung by a prior decision doing the opposite? The Supreme Court anticipated this question, and it said that stare decisis, statutory stare decisis, still applies to the holdings in the cases that the specific agency action is lawful. That's the court's language. To the holdings in these cases that the specific agency action is lawful. And furthermore, the court said reliance on Chevron itself was not a special justification entitling the court to overrule the precedent, notwithstanding stare decisis. Justice Kagan, who of course dissented in the case, was not convinced that lower courts would listen, and she warned of the shock to the legal system that would result, all the reliance interests upset, when courts came up with one reason or another to overrule precedent. It's certainly too soon to evaluate this concern, but I want to focus for a moment on an interesting turn in some lower court decisions, particularly in the Sixth Circuit, which is my circuit. Judges are reading the court's peculiar phrasing, stare decisis applies to the holdings in prior decisions that the specific agency action is lawful. They're reading that narrowly, so that stare decisis is out if the agency has changed the regulation under review in some respect. They have done so on the strength of a narrative that the Supreme Court adopted and deployed in Loper-Bright in support of overruling Chevron, that Chevron enables, if not invites, agencies to change their legal interpretations as much as they like, even 180 degrees. And that really comes from a narrative that Justice Gorsuch deployed before he joined the court, but in Loper-Bright, that narrative really came through. The court embraced it. Now, the Sixth Circuit, when confronted with an example of such agency whiplash, that's the word the court used, the Sixth Circuit imported the Supreme Court's reason for overruling Chevron, that agencies could flip-flop as much as they like. So that was their reason in part for overruling Chevron. The Sixth Circuit adopted that narrative as a reason to disregard precedent, the court's own precedent and its own precedent, in order to decide the meaning of the statutory language under consideration anew. Moreover, the judges used the occasion to read the court's stare decisis assurance narrowly. Only the specific holding was entitled to stare decisis protection. So any regulatory change put the statutory language up for reinterpretation. And maybe only Supreme Court decisions, Supreme Court precedent, was entitled to stare decisis weight, which means that lower courts do not have to accord stare decisis protection to their own precedent. And this was an issue that Justice Amy Coney Barrett raised when she was an academic, that maybe statutory stare decisis only applies with full force to Supreme Court decisions and not to lower court decisions. So this was on the table, at least in the Sixth Circuit. Now, this is just a data point. It's not widespread, even on the Sixth Circuit, and it was in response to an admitted instance of agency whiplash, a flip-flop, 180-degree turn on an important issue, in particular net neutrality. So that's a big one. But these instances got me and my colleague Kevin Stack thinking. How frequently did agencies flip-flop or reverse their legal positions under Chevron? It's really an empirical question, isn't it? So was this the right picture of agency action? And shouldn't we care not because it mattered to whether the court should have overruled Chevron? Actually, Dick Pierce wrote a really good article leading up to Lower-Bright where he said like even a few instances of agency whiplash are sufficient perhaps to overrule Chevron. That's not the question that Kevin and I were interested in. We were interested in whether the story was accurate or remotely accurate because it seemed to still exist. It lingered. It carried forward after Chevron was overruled and into the Loper-Bright universe. So what we did is, very quickly, we looked at 2 decades of DC Circuit cases. So we moved out of the Sixth Circuit and back to the DC Circuit where a lot of regulations came under judicial review, and we know the DC Circuit to have been the administrative law circuit. So we looked there, and we found little evidence that agencies flipped-flop. Certainly not sufficient evidence to support this broad narrative that the court deployed in Loper-Bright. Certainly not enough for lower courts to be concerned that any regulatory change was an issue. I think fairly speaking, we found one outright flip-flop. And interestingly, that flip-flop involved net neutrality, the very issue that's in the Sixth Circuit. We did see a lot of changes, though. We did see that agencies changed their regulations in some respect a lot. And this is not surprising. It's consistent with an important study that Wendy Wagner and her co-authors did about regulatory change in response to this idea that regulation is one and done. Agencies promulgate a regulation and never again visit it. That's, they said, or they found in an extensive study, not true. Agencies change their regulations in many ways. They change application based on fact, as we would expect them to do. They revise based on technical errors and date revisions. They clarify, lots and lots of changes. But none of these changes, in our estimation, rose to the level of anything approaching a reversal or the idea that agencies could change their views as much as they like. And so we stepped back and we said, well, the picture we're seeing is not one of agency whiplash. The picture we're seeing under Chevron is really one better described, we think, as settled equilibrium. And this is building on the work of Eskridge and Fricke, famous work where we think we can sort of describe, based on their work, the way in which Congress delegates. Agencies take legal positions as necessary to implement their statutes, and courts affirm them, or they did affirm them, under Chevron. And that this judicial affirmation sort of quiets the law. It doesn't invite agencies to come back and revisit their legal positions over and again as much as they like. This regulatory equilibrium that we see has very different implications for statutory stare decisis. Courts should be reluctant to upset the equilibrium. They should be reluctant to be the prime movers in overruling and undoing the law where it's settled under Chevron. And this should apply to lower courts, maybe more so, and lower court decisions maybe more so than the Supreme Court, because then it's one lower court or one circuit unsettling precedent that has come to rest. And this is sort of a view of the reliance interests that are at issue. It's not just private investment. Justice Kagan is right about that. But it's this whole notion of law as coming to rest in a particular way, especially once the court sort of blessed the interpretation, which is not really how we think about it, by affirming the agency under Chevron Step 2. So we think that this is important, not because we are denying the extreme examples of whiplash that courts no doubt will face, but because in the run-mill of cases where stare decisis might come up, courts will continue to confront regulations that have changed in some respect. And they ought to be mindful of that, rather than adopting a very narrow construction, as the Sixth Circuit perhaps is doing, and looking to overrule what's behind them, looking to stop the vacillation, which is really interesting, by overturning and unsettling the law yet one more time to get it right as they assess it. So that's really where I'd like to stop today, after sort of raising that issue that I think we may have to confront perhaps more than we might have thought. Thank you.
Thank you. Kristen?
Sure. So I'm also going to talk about Loper-Bright. Lots of us are talking about Loper-Bright, or at least we were before January 21st. So what I want to talk about, what I've been focusing on with Loper-Bright, you know, we can all quibble with maybe what the Supreme Court has done or what they said in the Loper-Bright opinion. What's interested me is thinking about how the lower courts in particular are going to proceed. As I see the Supreme Court, you know, one of their jobs is to, you know, not just, you know, interpret the law, but also in some instances to operationalize it for the lower courts, to help the lower courts resolve the much larger dockets that they have. One of the difficulties, I think, with Loper-Bright is, even if you're sympathetic with a lot of the things it has to say, is it doesn't do a great job of guiding lower courts. Post-Loper-Bright, every single Supreme Court case every single court case involving statutory interpretation in an agency context is citing Loper-Bright and saying it means X, Y, or Z. Many district court and circuit court opinions are citing Loper-Bright, and in many instances indicating they're not entirely clear on how they're supposed to be applying it. So in trying to think about that and looking at the Loper-Bright opinion, there's a lot of discussion in Loper-Bright about independent judgment, that courts are supposed to exercise their independent judgment to employing traditional tools of statutory interpretation to identify the best reading of the statute. Great, for what it's worth. But there are these two paragraphs in there that set up a different regime. They talk about, they admit that sometimes Congress expressly delegates policymaking discretion to agencies, and they provide some loose examples and a couple of footnotes with specific citations to particular statutory delegations. And then they say when the best reading of the statute is that Congress intended to delegate policymaking discretion, the role for the courts is different. The court's role then is to identify the boundaries of the express delegation, to decide whether it's constitutional, and then so long as it's constitutional and the agency is sort of within its boundaries, then review for reasoned decision-making, in other words, state farm. So we've got an independent judgment bucket, and then we've got a state farm reasoned decision-making bucket. Frankly, those are the same two buckets we had under Chevron. So, some people have looked at Loper-Bright and they have said that it really didn't change anything. All we really did was change the rhetoric. We haven't really changed what judicial review is going to look like. I don't really think that's right, because I don't think the Supreme Court overturned Chevron in order to change nothing. On the other hand, there are lots of people who sort of ignore those two paragraphs or want to minimize those two paragraphs and talk about how is the Supreme Court going to interpret all of these, highly technical, scientific, what have you, actions by agencies where there's very little in the statute actually to interpret. I don't think that's right either. But in terms of operationalizing Loper-Bright, I've been trying to think about how to read Loper-Bright and apply it in a consistent manner, to guide courts. And I will be the first one, my co-author and I, we will be the first people to say, the scheme we have come up with is not something the Supreme Court has explicitly endorsed. And yet, drawing from cases like Batterton versus Francis that the Supreme Court cites favorably in Loper-Bright, drawing from some work by my co-panelist and former professor Tom Merrill and Catherine Watts, as well as some work that I've done on myself in the past, just looking at different kinds of delegations and thinking about what language of delegation in statutes means. We've come up with a scheme that we think actually fits with all the citations in Loper-Bright and with what the Supreme Court has done with Loper-Bright since, which is you can look at statutory delegations, and I think you can divide them into three buckets. You've got specific authority delegations or express delegations where Congress has a substantive provision that is calling, that is laying out statutory requirements or, the broad outlines of a program or some sort of prohibition or whatever it is that statutes do substantively. And the statute then says, agency, whatever secretary or administrator or director, whoever, shall have the authority to adopt rules and regulations to accomplish XYZ congressionally identified substantive goal. Adopt uniform rules of accounting, adopt rules to enable taxpayers to file consolidated and affiliated tax returns. Congress identifies the gap, in other words, and says agency promulgate regulations to do this. That clearly falls in the two paragraphs. There may be some interpretation involved, but that very obviously fits, all of the examples in those two paragraphs that the Supreme Court cited are these kinds of delegations where Congress is explicitly calling upon the agency to exercise some amount of policymaking discretion, and reasoned decision-making makes sense. The second kind of delegation, lots and lots of regulatory statutes contain what tax people refer to as a general authority provision, or Marilyn Watts described as a housekeeping grant. You've got a section of the statute, often in the administrative provisions of the statute, not the substantive ones, potentially labeled something like rules and regulations or powers of the administrator or what have you, that says something like the following. The Secretary shall have the authority to adopt all needful rules and regulations for the enforcement of this act. There's no specific linkage to substance beyond the four corners of the statute itself. There's no identification of particular subject matter to be addressed beyond the four corners of the statute itself. It's essentially, agency, you go figure out where you think a rule or regulation is needed, although you might be able to quibble with how broad or narrow that is if it's focused on accomplishing the purposes of the statute or needful for enforcement of the statute or whatever language the particular provision might use. In thinking about Loper-Bright, all regulations like this, notwithstanding the fact that Marilyn Watts persuasively argued, I think, that the original idea was that these sorts of delegations could not support, or were intended to be housekeeping in nature and not support legally binding regulations. And back in the 30s and the 40s, the general consensus among legal scholars seemed to be that if they could support legally binding regulations, that would violate the non-delegation doctrine. The Supreme Court has long since concluded you can adopt legally binding regulations under these sorts of delegations. The non-delegation doctrine being what it is, you can easily see why it would survive the intelligible principle standard if you're thinking about text and context of the larger statute that has a lot of details on its own. But that doesn't mean we have to give it these regulations reasoned decision-making review. These might be the kinds of regulations where independent judgment, maybe with some Skidmore factors, makes sense. And in thinking about these delegations, also potentially confining them to the kinds of interpretations that you can get to through traditional tools of statutory interpretation. Not all regulations, I think, that are promulgated under general authority necessarily could be reached through the application of traditional tools of statutory interpretation, but a lot of them probably could. I mean, I'm a tax lawyer, and I think, just to give you one example, we tax as income compensation for services. We had a long debate for many, many years in lots of court decisions about whether tips are gifts that aren't taxable or are compensation for services. And, there were some courts that said gifts, and there were more courts that said compensation for services. Eventually, Treasury promulgated a regulation that said tips are income. They're compensation for services, not gifts. But you could easily get there through common law type reasoning using traditional tools of statutory interpretation. There's no specific authority delegation there. They use general authority to promulgate that reg. Well, maybe that's what general authority ought to be, and then independent judgment makes sense, okay? Then you've got hybrid delegations, which are provisions within substantive provisions of a statute. They're sub-provisions, so like lots of sections of statutes. You've got substance, 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 and you get down to subsection K, and it says something like the Secretary shall have the authority to adopt rules and regulations as needed to effectuate the purposes of this section, or something like that, right? And then maybe it'll even have including and offer a couple of examples. that kind of general authority language in a specific substantive provision, we've labeled hybrid delegations. And we've argued because, you do have substantive context right there, that we ought to treat those more like specific authority grants and give them reasoned decision-making review, rather than treating them like general authority or housekeeping grants and giving them independent judgment review. Again, the Supreme Court hasn't adopted this. It's a way of looking at Loper-Bright and thinking through how might we operationalize it in a way that is manageable for lower courts. I will point out that in Bondi versus Vanderstock, the ghost guns case that came out a couple of weeks ago, the regulation at issue seems to have been promulgated pursuant to general authority or housekeeping authority under the Gun Control Act. And Justice Gorsuch applied independent judgment as his approach. Now, Justice Jackson wrote a concurring opinion in which she said, we ought to, that Congress has delegated authority to the agency, that ought to be enough. So she's not necessarily on board with this categorization that I'm describing. But thus far, anyway, post Loper-Bright, between Loper-Bright itself and the ghost guns case, this seems to fit with how we're thinking about things. A couple of normative points, or additional doctrinal points, excuse me, and then I'll wrap it up. As we work through it all in the paper, we think that this approach not only sort of has Loper-Bright doing something without having Loper-Bright blow up the world. We also think that this approach makes it a lot easier and less needful to apply the major questions doctrine. And we think it addresses some of, at least, of what the Supreme Court may be concerned about in terms of the non-delegation doctrine, but at a subconstitutional level, to further make it less needful for a Supreme Court that wants to rein in administrative excesses to replace the intelligible principle standard. So we like this approach because we think it accomplishes a lot of what we think the court is trying to accomplish. We'll see if it pans out.
Great, thank you. Anita?
Thank you. I also want to start by thanking the NYU Law Review and the Center for Policy Integrity and Don Goodson for inviting me to participate in the symposium today. And I look forward to discussing these topics, the future, I guess, or changing landscape of administrative law with all of you shortly. So I'm a statutory interpretation scholar who still feels like a little bit of an interloper when I'm asked to present on a panel with administrative law scholars, although I teach, I teach administrative law and have taught it for many years. So I also did not write a paper for the Law Review, so I'm going to give you some thoughts off the top of my head, sort of remarks about what I think cases like Loper-Bright and the so-called major questions cases might portend about what we can expect to see in the near term for the judicial review of agency statutory interpretations. And basically, I want to talk about three trends that I think we can see sort of emerging out of these recent administrative law cases, because I think they're likely to stick around for a while, and maybe to characterize the way courts conduct judicial review of agency statutory interpretations, and maybe can try to, like everybody else, give us a little bit of an idea of legal hooks that we can put our hands on that the court might continue to use across cases when it's trying to figure out the meaning of statutes. So there's just 3 points, and I'll talk about each in turn in a second. But first is that I think the recent cases suggest and confirm maybe that legislative history is likely to continue to play some role on the Roberts Court in its construction or determination of what regulatory statutes mean. And to some, that might seem surprising in the sort of post-Scalia 6-3 textualist supermajority on the court era that we're living in right now. But I think it's a reality, and I think it's here to stay for a number of reasons I want to talk about. I think we also should be paying attention to what courts characterize as questions of law versus questions of policy. A lot of that is very much motivating, I think, Kristen's excellent paper, and I think it's a really important question after Loper-Bright, and the landscape has changed on that since Chevron. Going forward, I also think we can expect to see a lot of weight placed on established government practice, so what kinds of policies, regulations, et cetera, a particular agency has promulgated in the past and how similar or different that is to the agency regulation at issue in a way that I think goes beyond just sort of the consistency or longstandingness of a particular interpretation that used to be factors under Skidmore. So first, start with legislative history. The Roberts Court has invoked various forms of legislative history in several of its most recent high-profile agency statutory interpretation cases, which I think is noteworthy because despite the court's supermajority of textualist justices, and despite the fact that Justice Scalia, when he was on the court, used to sort of insist that Chevron Step 1 did not include legislative history and was supposed to be based on the text of the statute, that's something he and Justice Stevens bantered back and forth about. The court going forward, I think, is likely to look at the statute's legislative history and even subsequent actions by post-enactment Congresses to help figure out the parameters or the scope or the reach of an agency's delegated authority. Consider, for example, Loper-Bright, right? Although the court's opinion places a lot of emphasis on Article 3 judges as the arbiter of legal questions and cites Marbury versus Madison, right, for the proposition that it's the court's job to say what the law is. In the end, the opinion ultimately rests its overruling of Chevron on an analysis of Section 706 of the APA. And in so doing, it relies pretty significantly on multiple forms of legislative history, right? Not just House and Senate committee reports, which are sort of considered the most authoritative forms of legislative history, but also on less authoritative and less widely respected and often criticized, especially criticized by textualist forms of legislative history like floor statements by the APA's supporters in Congress, the Attorney General's manual on the APA, which isn't even a form of legislative history that's created by Congress, right? It's a much more attenuated form of legislative history. And also in some of the major questions cases, the court has pointed to subsequent legislative history, i.e. the fact that the present day Congress or some Congress along the way, right after the enactment of the statute, explicitly disapproved of or considered and rejected adopting the policy that was eventually adopted by the agency, and that's at issue in the case, as sort of a sign of whether or not the agency had the authority to enact this kind of policy. So for example, in NFIB versus OSHA, of course, the court cited the Senate's disapproval resolution disapproving the vaccine or test mandate. In West Virginia versus EPA, the court mentioned that Congress had considered and rejected cap-and-trade regimes in rejected legislation that looked similar to some of the cap-and-trade policies in the Clean Power Plan. And some of the subsequent legislative history, of course, represents the work of just one house of Congress, so there's no bicameralism. Some of it entails rejected proposals, sometimes rejected by one house, sometimes rejected by both houses, which certainly have not gone through the Article 1, Section 7 process. All of it is the kind that textualists have long criticized, and yet the court was quite willing to rely on these forms of legislative history pretty prominently in these cases. And I think that's a trend that will continue even in more run-of-the-mill cases. Right? And I point this out not so much as like a gotcha moment on textualists, more as it's not about highlighting the inconsistency of criticizing these forms of legislative history and then relying on them. It's really because I don't think these are just one-off or accidental uses of legislative history that are in these high-profile cases because they're unusual or sui generis cases. I think this is really a sign that legislative history remains an important source of information, even on the current textualist court. And I've argued in a recent article that I published elsewhere that I think the court is actually far more pluralist than purely textualist, even with its 6-3 majority, and that we do see reliance on these kinds of things. And I think we are going to see reliance on legislative history in agency statutory interpretation cases more than we have perhaps in the Justice Scalia Chevron Step 1 era. The second thing, or the second point that I talked about, what gets characterized as a question of law versus a question of policy. So Justice Kagan's dissenting opinion in Loper-Bright spends a good 1.5, almost 2 pages detailing several different interpretive questions that she says would have gotten Chevron deference in the past, and that she argues courts will now treat as questions of policy, they would have gotten Chevron deference in the past, and that courts will now treat as questions of law that they will review de novo rather than deferring to an agency's policy judgment about. These include things like, when does an alpha amino acid polymer qualify as a protein under the Public Health Safety Act, or under the Endangered Species Act, is the Washington western gray squirrel a distinct population segment from other western gray squirrels if it's geographically separated from those other gray squirrels. So in other words, the question of what makes a population of a species a distinct population segment, and so on and so on. Right? She spends quite a bit of time outlining some of these questions. And I think it's important because Chevron in some ways blurred this question or issue, right? Because it said when an agency interpretation is it qualifies as a question of policy, essentially, that we're going to defer to agencies on whenever the statute is ambiguous about this, right? So we didn't have to get into these thorny questions, but for the reasons that Kristen has really outlined in her paper, it's going to really matter now whether the court considers something a question of law or a question of policy. And it looks, at least from the sweeping language of Loper-Bright, that it might consider many more things to be questions of policy, many more questions to be questions of law than of policy than it has in the past. And I think it's a really important thing for those who are advocating on behalf of agencies to think about. How do we characterize this as something that's technical or that is scientific or otherwise really is a policy question, so we avoid the de novo judgment and get more deference for the agency. Last, I think the court is already shown us that it's going to put some weight on, and I expect to see this continue in the future, how established the agency's action is, or how connected the agency action or interpretation at question is to prior things that are the kinds of things that the agency has regulated in the past, right? So kind of tying up in a bow as much as possible, or drawing connections between the action the agency is taking and the actions it has taken in the past, I think would be helpful to agencies, and it's something to pay attention to or be wary of in the context of new regulations, right? I also think we're going to see a lot of weight continue to be placed on the specific kind of expertise that the agency is known for, the subject matter that it has expertise in, and somewhat of a narrow line drawing around that agency expertise. So again, in some of the major questions cases, the court said the CDC shouldn't be regulating eviction moratoriums because the CDC's sphere of expertise is public health, and even if evictions might lead to greater spread of a disease, that's too attenuated of a concern, and its expertise doesn't have to do with landlord-tenant relations. OSHA can't impose vaccine or test mandates because its expertise is workplace safety, not public health. And I think we will continue to see that kind of sort of cabining of agency discretion, and it's also something for courts to pay attention to. Again, some of these things are connected to things that were relevant factors in the pre-Chevron Skidmore era, but I think we're seeing kind of fine points put on them. In the interest of time, I will stop there, and I look forward to your questions.
Tom?
Thank you. My thanks also to NYU and the Center for Policy Integrity for hosting this and inviting me. It's clear that the Supreme Court has been on a kind of anti-administrative state tear. Not only do we have Chevron being overruled, but we had intimations that maybe the non-delegation idea was going to be reinforced. In the Gundy case, in particular, set that off. So far, no follow-up, although the court has granted cert and has heard argument in a case this term called FCC versus Consumer Research, which squarely raises the non-delegation question again. I'd be a little surprised if we see the Gorsuch vision in Gundy adopted, but that remains to be seen. Some other notable decisions, like Jarkissi extending the Seventh Amendment to civil penalties adopted by administrative agencies, seem to me to be wrong, but kind of easily cabined. The SEC can always just send the civil penalty cases off to Article III judges and avoid the impact of the Jarkissi case. Loper-Bright, the theme of this panel was supposed to be creative destruction or something like that. It seems to me that Loper-Bright did have the potential to be a kind of example of creative destruction. Like many law professors, I was very intrigued by what Kristen calls the two paragraphs, I interpret the two paragraphs as basically saying that pre-APA law included these sort of traditional canons of interpretation that agencies get respect or weight when they have interpreted something contemporaneously with the statute or when they have acted in a consistent and longstanding fashion to interpret a statute a certain way. They also sort of reaffirmed Skidmore, which was a pre-APA decision, sort of suggesting that Skidmore would become a general canon of interpretation that courts could draw upon. And finally, as Kristen emphasizes, there's these intriguing statements about maybe in some cases Congress will have signaled that it's given or it's delegated interpretive authority to an agency by the type of language that they use or perhaps by the type of rulemaking that they've granted to the agency. So I wrote an essay about Loper-Bright in the Harvard Law Review in November in their Supreme Court issue, and I was trying to describe the case, but it was also an exercise in spin control because I was trying very much to sort of urge that this kind of reading of Loper-Bright as preserving a significant role for agency interpretation in addition to judicial interpretation when questions of statutory meaning come up in the context of judicial review. I was hopeful that would be the way in which courts would read Loper-Bright, and offered various reasons in support of that. But I'm now increasingly pessimistic, one reason is I think looking back at the whole sequence of events, why did the court lose faith in Chevron? Why did it stop citing Chevron in 2016? Why were all these little concurring and dissenting opinions, dissents from certiorari written complaining about Chevron before the court gets around to overruling Chevron and Loper-Bright? And looking back at that history, it seems to me that many of the justices all had slightly different reasons for hating Chevron. Some of them were quite far-reaching. Justice Thomas, who was in an earlier incarnation of his career a big proponent of Chevron, decided that it was unconstitutional, that it sort of taking away the power of the courts to say what the law is, to use the Marbury expression, was a violation of Article 3 of the Constitution, and giving agencies the power to interpret statutes subject to sort of binding deference by the courts was a violation of Article 1 of the non-delegation doctrine. Well, he was occasionally Gorsuch would throw in his hat, but he was kind of out there by himself on the constitutional end of things. Gorsuch is interesting. He's kind of the most populist, or sees himself as a populist justice, and he complained about Chevron because he felt that it was unfair to ordinary people, as he put it. It was in a fight between the government and ordinary people. Chevron says the government wins, and this was a form of bias against the ordinary Americans. He also emphasized, and I think this has been touched on as well, that Chevron promotes instability in the law because it allows agencies to flip-flop and change their views about things whenever they feel that it's time to change their views. The implication being that as administrations turn over, the law turns over because agencies will automatically reflect whatever the current administration wants them to say. Justice Kavanaugh had written an article, actually it was a long book review in the Harvard Law Review while he was sitting on the DC Circuit. And his critique, which reflects some of the academic critique of Chevron, was that this threshold determination of ambiguity, that agencies get deference when the statute's found to be ambiguous. This was kind of a hopeless idea because every judge had different ideas of when ambiguity is present and when it's not, and so Chevron leads to this incoherence among the federal courts as to when they should defer and when they shouldn't defer. And lastly, but certainly not leastly, the Chief Justice Roberts, I think, in a very well-known, or at least to me well-known, dissenting opinion in Arlington County versus FCC, which is one of the earliest opinions by the court sort of cavilling against the evils of the administrative state. Roberts said that the problem with Chevron, or at least one version of Chevron, was that it didn't allow courts to decide what the scope of authority of agencies is or what their jurisdiction happens to be. So you had a whole looking back, different justices have different ideas about what was evil about Chevron. So the Loper-Bright opinion is kind of a surprise because Chief Justice Roberts writes this lengthy opinion in which he says, guess what? The problem with Chevron is it violates the Administrative Procedure Act, Section 706. Now that had been maybe alluded to a little bit in some of the Thomas Gorsuch dissents from denial of certiorari, but it certainly was not the thing that was sort of bugging the justices that didn't like Chevron. It wasn't the primary thing in any event. So that was kind of a strange development. I happen to think that Roberts' interpretation of the APA is very unpersuasive, and Kagan, I think, completely dismantled it by saying, well, the APA says that courts have to decide all relevant questions of law, but doesn't say what the standard of review is, and we've had like umpteen years of history in which the courts have been developing the standard review of questions of law without anybody screaming and yelling that this violates the APA. Anyway, so if you think of Loper-Bright as a kind of a coalitional document, the Chief Justice is writing an opinion in which he can get 6 votes to overrule Chevron and adopting a kind of a framework for that overruling, which doesn't necessarily buy into all of the different views the different justices have, although there's some hints and gestures in that direction here and there. The pessimism comes about because you think, well, going forward, it's not just that the lower courts don't understand Loper-Bright, the Supreme Court doesn't understand Loper-Bright. And probably the lower courts are going to wait and see what the Supreme Court does with Loper-Bright, but what the Supreme Court's going to do with Loper-Bright depends on who's assigned to write the majority opinion. And I think there's already some there's already some straws in the wind, as I shall put it, that suggest that this is what we're going to get. The Supreme Court's first post-Loper-Bright statutory interpretation opinion that is reviewing an agency is a case called City and County of San Francisco versus EPA. The question had to do with San Francisco's permit to discharge from combined sewers. Basically, they're discharging stuff from sanitary sewers into the Pacific Ocean. And the EPA's permit included, among other things, a requirement that they preserve the water quality standards of the Pacific Ocean without specifying exactly what monetary limits on discharges they had to comply with. So this goes up to the Supreme Court. It's a particularly interesting subject matter because in the 2 paragraphs that Kristen is highlighting, the court has a footnote in which it cites Section 1311, or maybe it's 1312 of the Clean Water Act as a good example of where Congress has given highly discretionary language to an agency to allow it to interpret the statute that it administers. So Justice Alito gets assigned to write the majority opinion in San Francisco versus EPA, and there is one citation to Loper-Bright in which Justice Alito says, well, the EPA has some guidance documents that say that these sorts of permits that just limit you from violating water quality standards without telling you exactly what numerical limits you have, that's just their guidance document, and we under Loper-Bright, we're entitled to enforce the statute against contrary agency understandings. So that's the end of it. Justice Alito engages in a torturous exercise in quoting dictionaries and so forth about what the word limitation means, and he basically rewrites the regulatory scheme to say that these end result permit provisions are unlawful under the Clean Water Act, even though nobody ever understood that that was the case before. Also interesting is Justice Barrett writes a dissent. And Justice Barrett says, well, there's nothing wrong with these end result permit limitations. They can be useful in certain contexts when you have maybe multiple dischargers and you can't figure out exactly what limitations to set for numeric limitations. Basically, her dissent is channeling the EPA's interpretation of the statute. But guess what? She doesn't cite EPA's interpretation at all. She purports almost as if she's coming up with this interpretation as a matter of independent judgment herself. And there is some reference to legislative history, but the legislative history references are all citations to amicus briefs, not to what the EPA has said about the history of the statute that it administers. So that case made me kind of bummed out. It seemed like, this idea of maybe that Roberts was signaling that under the Clean Water Act there had been sort of the delegation of authority to interpret to the EPA was not really being taken seriously by at least Alito and Barrett. And Loper-Bright is understood by Alito at least to mean that, well, we decide everything ourselves without regard to, as if the agency doesn't exist. It's pure de novo review. Then we have the Ghost Guns case, which has already been mentioned, where again, well, in this case, the Justice Gorsuch writes, he upholds the agency. When we get into the details of things, he does finally get around to referring to Loper-Bright and says that we will rely on the agency with respect to this sub-issue because the agency has consistently and over a long-standing period of time interpreted the statute this way. So that was a big theme of Gorsuch's leading up to Chevron. He thought that the agencies were sort of flip-flopping too much and they weren't being consistent, and that was a big problem with Chevron. So he's willing to cite Loper-Bright when it sort of agrees with what his criticism was, but not otherwise. So these are just little straws in the wind. Admittedly, but it kind of suggests to me that maybe what we're going to get is not just going to get chaos in the lower courts, we're going to get chaos in the Supreme Court because each justice is going to write a post-Loper-Bright opinion that sort of reflects what they think was wrong with Chevron or what they think is to be substituted for Chevron, and pity the poor lower court judges that have to figure things out if that's what we get. Thanks.
Okay, well, on that depressing note. Okay, so let me just add just a sort of housekeeping matter. So for those of you who have signed up for CLE, I've been asked to announce the CLE code, and the CLE code is aptly LOPER, capital L-O-P-E-R. So LOPER, L-O-P-E-R. Okay, so I'm just going to ask one or two questions, and then I already have a few audience questions, but if people have note cards, if you just hold up your note cards, there are people collecting the note cards who can bring them forward to me. Okay, so as a number of people today have already alluded to, Loper-Bright, the case that many of you talked about, but also some of these other cases that you've talked about really predate the change in administration that we've seen in January. So given the new context in which we're operating, I wanted to ask you a couple of questions. One is a question about, do you think that these cases, and maybe you can focus on Loper or other cases, West Virginia, other cases, do you think that these cases from the court, do they open up new opportunities that might not have existed before for people challenging the creative destruction of the new administration? So are you seeing kind of interesting uses of some of these doctrines, like the Loper-Bright or the major questions doctrine, or other things in some of the challenges, to the extent you're following them? And in sort of raising this question, I was thinking a bit about this challenge brought by the New Civil Liberties Alliance to the imposition of the tariffs on China under the International Emergency Economic Powers Act, where they cite Loper-Bright, they cite the major questions doctrine, the non-delegation doctrine. So I'm curious whether you think that these doctrines, how you think they might be used by challengers, and then secondly, how do you think that the new context in which the court will be applying these doctrines might influence the way the court applies these doctrines?
Well, I guess I'll say something. We're in a very tricky situation here, particularly insofar as the law that's being made, if it's not law in quotation marks, is based on presidential executive orders. The APA, according to the Supreme Court in some 1990 decisions, does not apply to the president. So the obvious way of challenging the stuff that's coming out of the White House which would be to use the APA, does not exist. So anybody that's challenging what's going on is going to have a tricky problem. They're going to have to figure out how to name as a defendant some agency administrator or something, and say that what they're doing, although it's pursuant to a presidential directive, is unlawful. Maybe there's a way to get around that. I would strongly urge that care be taken to try to select plaintiffs who are are the subject of aggression by the federal government. So they're being charged tariffs or something like that, or being sued for not paying tariffs or something. I think that's a more attractive posture, and it overcomes certain standing problems and so forth. I'm not a fan of the major questions doctrine. I think it was a very wrong turn by the Supreme Court. I think it invokes various criteria, which are ones that courts are not particularly traditionally understood to be well suited to decide on. Things like how politically controversial is the issue, how many people are affected, how many dollars are affected. Has Congress failed to legislate on this question or not? That I guess the courts can figure out. But it seems like not really a doctrine of conventional legal interpretation of the conventional role of the courts, but a kind of more of a policy-laden intrusion. So I would sort of hope that one of my hopes about Loper-Bright, talking about creative destruction, was that Loper-Bright would render the major questions doctrines unuseful, and the court would just quietly let it fade into the past. But certainly the major questions doctrine fits the tariffs like a glove. We have this IEPA statute, which the president invokes for his authority to impose tariffs on every country in the world, or then rescind them and then reimpose them and rescind them and so forth. This would seem to fit the major questions doctrine quite nicely. So there's some prospect that courts or the Supreme Court will invoke the major questions doctrine. It fits because previous presidents have not used this ridiculous statute. This is a statute that confers unbelievable discretion on the president with respect to emergencies caused by international events that affect, among other things, the economy. So maybe that's a non-delegation problem. But the court could easily say that it's never been used for tariff purposes before, so this is a kind of a novelty that the major questions doctrine sort of focuses on. And it's kind of implausible to think that it discusses tariffs because there is a standing authority for divisions of the Commerce Department to decide whether or not there needs to be adjustments in tariffs using a kind of traditional administrative notice and comment type procedures, which would suggest that Congress, having that on the books, did not suggest that IEPA was supposed to create this sort of unilateral inherent authority in the president to set tariffs. So maybe major questions will live on in the guise of doing battle against some of the Trump stuff, which would be probably unfortunate. I think it'd be much better to use Loper-Bright type review to nix these, this idea of tariff authority.
I would add, so some of the Trump EOs are very clearly intended to push the Supreme Court's recent precedents regarding things like removal power, and appointment power and agency design, where the court, for example, in Saylor Law or in Lucia, or, some of these cases talking about different officials, not, not the CFPB not being an independent agency, you can't, or not having two layers of for-cause removal restrictions or what have you. Clearly intended to try to extend those by applying them to other agencies, clearly intending to generate judicial challenges to try to extend the applicability of those Supreme Court decisions. So those are instances where we just have to wait for the litigation to unfold, I think. And there's no question that the court's going to end up, or at least the lower courts are going to end up having to grapple with the applicability of those relatively recent precedents to these other facts and circumstances. And maybe the Supreme Court will be taking up some or all of them. Those aren't particularly major questions doctrine or Loper-Bright, but they are, picking up on the larger suite of precedents from the last several years, and I think very deliberately trying to drive them forward and expand their reach. It's a little harder with things like Loper-Bright and major questions, I think, for the same reason that I mentioned before. It seems like every single case that involves an agency interpretation of a statute has litigants raising major questions doctrine or Loper-Bright arguments, even where, some of them probably are good arguments, but even when they're not so good, at least from talking to litigators, it seems like, well, we've got to throw in our major questions paragraph, and we've got to throw in our, Loper-Bright paragraph, or what have you, because those are the doctrines of the moment. That potentially leads, I think, to some, really confusing case law, because the arguments often aren't very well developed. The lower courts with very heavy dockets often aren't in a great position then to try to theorize whether or to what extent these doctrines ought to be applied, extended, theorized, what have you, which creates, I think, the mess that Tom is talking about, just further extends that mess. So I don't know how useful Loper-Bright or major questions doctrine is going to be in terms of combating some of the things that, or, evaluating some of the things that the Trump administration has been doing, but ultimately a lot of those will end up being statutory questions, and the courts will have to grapple with whether and to what extent major questions doctrine applies, or how to apply Loper-Bright in evaluating the statutory questions that ultimately emerge through the various legal challenges.
Anybody else?
Speaking about removal, the Trump administration lawyers seem to think that it's inevitable that the Supreme Court is going to declare that the president has the right to remove at will any member of a multi-member regulatory commission. He's already fired the FTC commissioners that he doesn't like, an NLRB board member he doesn't like, the independent counsel that works with the whistleblowers, and I guess the members of the Merit Service Review Board. I brought to mind the Humphrey's Executor is the case they want to overrule, but Humphrey's Executor has a sort of interesting background story. It was the decision of the Supreme Court that most angered Franklin Roosevelt, because he was trying to dismiss Mr. Humphreys, who he said did not see eye to eye with him on policy. A 9-0 decision of the Supreme Court says, no, sorry, he's protected against removal unless he's done something, some dereliction of duty that constitutes cause. This is entirely speculative, but I think maybe the Supreme Court thought that FDR was acting like a bit of a dictator and needed to be brought up a bit for violating the law based on some kind of claim of inherent presidential privilege. So maybe the Supreme Court will have a similar reaction to firing every independent commissioner.
So anybody want to put money on that? Anita, I'm just sort of curious whether you think in the new environment you'll see any changes in approach sources for statutory interpretation. Do you think that your kind of predictions or your sort of the themes that you identified, do you think that they will persist?
In the new environment? I think so. So interesting. A lot of what's going on right now is not actually agencies taking action. It's undoing things. So it's a little hard to see directly how things will play out. But we have seen, there's an article I neglected to mention, a recent paper by Robin Kundis-Craig that looks at 6 months post Loper-Bright, which a lot of it is pre the Trump, but really interestingly finds that there's a difference between how judicial review of agency regulations versus agency adjudications and enforcements are being treated. And so far, agency regulations have a loss rate of 83.3%, which is a huge reversal, whereas agency adjudications seem to have a win rate of around 71%, which is pretty consistent with Chevron-era agency win rates. So it does seem like more evidence of a policy versus law split, maybe, that the agency adjudications are being treated more as questions of policy or fact, and the regulations as questions of law. Presumably that may continue, but we haven't seen a lot of new actions, right, that are of that format, so I'm not sure how it will play out exactly.
I want to make one cautionary note about looking at Loper-Bright applications in the first 6 months. I have a theory that at least some number of lower court judges, where you had agency actions that might have been on the border or that the particular judge was concerned about, they held them until Loper-Bright was decided. And so the cases in months immediately after following Loper-Bright may not be wholly representative of, there's a certain amount of cherry picking there, right? And that there may not be fully representative of the mine run of cases over a longer period of time. So, anytime I think the studies 6 months after are fascinating because, of course, we're all looking at the immediate aftermath, and we should be. But I also think that in order to really study empirically what's going on post-Loper-Bright, we need to have a longer period of time with actions taken after Loper-Bright was decided rather than actions taken before Loper-Bright was decided that just happened to get to the court. Or happen to get to decision in the months immediately thereafter.
I think also the circuits are going to split in their approach to Loper-Bright. So it depends where cases are filed, and we're seeing a lot of movement, so to the Sixth Circuit in particular. But we'll see how that unfolds. So depending on what was in the queue and where it's being brought and whether there'll be any, forum challenges, they've been largely unsuccessful so far. But I agree, it's super interesting to think about what's already happened, but projecting forward is difficult based on the sparse evidence we have. I want to say on this point about post-Loper-Bright executive action, I think there's enough in the case law about presidentially motivated flip-flops, which is what I wanted to talk about today. I think there's plenty in the existing case law, whether it's major questions doctrine, whether it's arbitrary and capricious review, for the court to take a stand if they care to. And I think it's been confusing for a long time. I think scholars on both sides have argued that there should be strong presidential control, and others have pushed back against that. And it's a little bit of the be careful what you wish for, depending on who you were wishing for. So I don't think we actually need new doctrine, but it's very, very difficult for lower courts to know what to do with that doctrine. We just got a new case where the court officially announced the arrival of the change in position doctrine under the arbitrary and capricious standard in White Lion, which I think they should have called White Lion because it's such a good name. But they called it the change in position doctrine, and they basically reinforced the ability of agencies on questions of policy to change their view, even 180 degrees if they can explain it and justify it. So on the one hand, there's suggestion from the court recently that it's okay for agencies to flip-flop in some sense, at least on policy issues. But how that applies to the president, there's a very good article by Ben Idelson about how arbitrary and capricious review contains the seeds of a kind of anti-presidential change doctrine or something of that nature. But, again, that's what scholars are writing. The seeds are in the court's cases, but whether lower courts can handle that, whether they'll split in handling it, whether the Supreme Court will take a strong stand, I think those are all the hard questions.
Yeah, I feel like we could spend an entire panel talking about wages in White Lion. Mm-hmm. It's another one of those kinds of opinions.
Mm-hmm. Yep.
So this is a question from the audience. So the question says, starts off with, will administrative law be able to bear the weight of the coming flood of litigation over the administration's aggressive deregulation? And then the next question is, how might that flood reshape administrative law? So what changes might you see coming out of the flood of litigation? You already referred to the removal power question? Do you see other things?
I think the question of whether the lower court should anticipate changes in Supreme Court doctrine, I think that's been percolating. I mean, I think that's been a big issue on the shadow docket, whether the Supreme Court itself, in applying the injunction standard, should anticipate changes that it might make in doctrine. So I think that's really going to come to the fore, whether lower courts are the ones to step forward. And most lower courts, I'm probably over-speaking here, but many lower courts, many circuits, have a rule, a self-imposed rule that they are not there to anticipate what the Supreme Court may or may not do. They are there to apply the law as it stands when they decide cases, but that's what's in question. Will that rule hold? The DC Circuit seems to think that rule should hold, but we'll see.
I think the courts can certainly, I mean, the courts have handled floods of litigation before. They're going to be able to handle floods of litigation again, in one way, shape, or form. That doesn't mean they necessarily are going to have the bandwidth to think through some of these issues as thoroughly as they might like to, in the need to push, as the need to push cases out the door is felt. I think it's troubling that the Supreme Court is only taking these days, 50 or 60 cases a term. There's sort of an extent to which you want to say to the Supreme Court, hey, you've opened this Pandora's box of pursuing substantial doctrinal change. And I'm not necessarily opposed to some of those doctrinal changes, although sometimes I question how they're articulated. But if you're only going to take 50 to 60 cases a year, and yet you're going to pursue this agenda of doctrinal change in a way that invites more litigation and places so much more of a burden on the lower courts, issuing 50 or 60 opinions a year and issuing opinions, candidly, like Loper Bright, that are not easy to figure out how to apply, verges on irresponsible. I'm not somebody who decries the current doctrinal change altogether, but lower courts are crying for guidance. If there's one thing looking at Loper Bright cases tells me, it's that lower courts are saying, we're not sure what to do. And that's creating splits over things like post-Loper Bright, what do we do with Skidmore? The court clearly endorses Skidmore and Loper Bright, but it doesn't really say what to do with it. And so you get the Fifth Circuit saying, we're not sure when Skidmore applies, and we're not sure how to apply it. So we're going to guess, and we're going to give you a couple of paragraphs thinking about it. But for that matter, that's just like a cry for help. That's a circuit court saying we need guidance. And you see lots of opinions like that. So, I think it's not the flood of litigation that concerns me, it's the relative lack of coherent guidance, which Tom's probably right, is because, the justices never agreed on what Chevron meant and how it should work. So I don't know why we think that they're gonna agree about Loper Bright and how it's gonna work, but still, they need to provide that sort of guidance to the lower courts in order to get, consistent, well-reasoned decisions in response to the flood of litigation.
Talking about a flood of litigation, at least in the administrative context, presupposes that agencies will actually be pumping out a lot of regulatory action.
True.
But the one thing we haven't mentioned is the efforts of the so-called Department of Government Efficiency to engineer large-scale reductions in force across many administrative agencies. It doesn't take too much insight to expect that these reductions in force are going to impair the ability of agencies to undertake new regulatory initiatives, even more impair their ability to frame them in such a way that's likely to be taken seriously by reviewing courts. Ask yourself, who's eagerly signing up to work for one of these agencies these days? Who wants to join the general counsel's office of one of these executive departments? Maybe this is the whole objective, is not to have anything happen at all, but maybe the courts won't have much to react to because there's nothing to react to.
Yeah, and in response to Kristen's comments made me think of Justice Scalia's dissent in Meade, in which he says, you know, Chevron is where he's very gung-ho and pro-Chevron, and says Chevron is the rule, Skidmore is dead and buried, don't resurrect it, and that maybe Skidmore worked in the early, you know, years of the administrative state, but we have, the administrative state has grown so much and we have so much regulation that we need a clear rule, right? And it's almost like when Chevron was in effect, lower courts applied it pretty regularly, and it helped guide them. The Supreme Court was still kind of a mess, right? As you said, it wasn't consistent. There are studies showing that it used other forms of deference, including Skidmore, in cases where you would have thought it would use Chevron. But it provided a clear, you know, framework for lower courts. And now that that's gone in Loper-Bright, we need the court to be clearer about what's replaced it in some senses.
On the other hand, let's not be too romantic about Chevron. I mean, you know, it worked pretty well for a little while, but as it had to be applied across such a variety of different agency actions, and as agencies became emboldened by Chevron to push the statutory envelope and to try to take advantage of deference, it became something of a mess. Partly because the Supreme Court couldn't decide, the justices couldn't agree, and so you'd get these splintered decisions sometimes, each with their own vision of how Chevron should work. And, you know, then the lower courts would sort of, you know, pick their favorite from the menu, you know, and that led to a lot of inconsistency over time in the lower courts as Chevron was being applied. And so, you know, in a different piece that I put out recently, I talked about the complexification of doctrine over time. And, you know, it may just, you know, I have a theory that Chevron just crashed under the weight of the complexities that developed as we tried to apply it over 40 years to so many different circumstances, and as agencies changed their behavior accordingly. You know, the same may be true with any sort of a standard like that, no matter how clear we make it. That may just be, you know, that's the kind of thing you have to look at over a long arc of like 100 years or something like that. So it's all speculation, but you know, let's not get too too eager to defend Chevron. It had its own issues.
So I apologize for interrupting, because I am really surprised by how quickly our time has run out. But Dawn has put us on a very strict diet schedule. So I just want to ask people to thank me in joining this panel. And thank you very much to the panelists.